The only time his time was restricted was 2.5 years ago, when the first motion that was filed, he did test positive for cocaine once.
Good morning. This is the time set for case D 21635-772D. I'll start with who we have here. Counsel, would you like to make your appearance?
Morning, Your Honor, or good afternoon. Dana Dwiggins and Ross Evans appearing on behalf of interveners, Julie and Paul Page.
Good morning, Your Honor. Thomas Standish for Dylan Houston, and this is my legal assistant, law clerk Julia Standish.
All right, welcome. And we have counsel for the protected minor, and I don't know, did you make an appearance in this case, Ms. Dalia-Hunt?
No, Marina Dalia-Hunt, bar number 15367C, representing the Houston children only in the guardianship case. I'm here in an observational capacity.
All right, thank you. And then we don't have Mr. Jones for the other intervener.
Correct. He said he was in court today, so he was unable to attend.
Okay, that's fine. All right, I'll tell you exactly where I am today. I don't really want to continue the trial, but I do believe there's enough regarding Dad's mental health that I would allow. It would really be either you can call it a brief focus assessment or psychological evaluation of just Dad. My preference in these matters is to proceed under NRCP 35, and the party requesting can pick their own expert and pay their own costs. This is not, especially in this case where it's not between parents. Okay. That's on the status check. I guess we got an email this morning from Dr. Collins saying that she has produced the remainder of her records to the attorneys by email. So I don't know if you guys, maybe that was just as of this morning.
It was, Your Honor, but I was speaking to Mr. Standish outside, and he could correct me if I'm wrong. But when the documents she was producing today was only supposed to be, if you recall, what she was provided by counsel. Her actual chart with all her notes and everything was previously disclosed. However, there were no psych evals in there or any other tests that she performed, despite there being references that she was conducting them. And then Mr. Standish did file an opposition and a counter motion this morning, which the counter motion I haven't been able to speak to my clients about, or any of it for that matter. But he indicated that Dylan had indicated that he did perform one or be subject to one. So
Subject to one what?
or that Dr. Collins had done a psych evaluation of some sort.
Yeah, Dylan can confirm that. And when we talked about it, they usually give the personality inventory to the MMPI, and he recalls taking them. Correct, Dylan? So.
That's correct.
So she may have
So we're
refused to
thinking
give you the raw
Ashley
data.
Probably took them too, but I don't know why the data was not in the chart. It appears not to be, so.
I think it just shows our repeated problem with Dr. Collins in this case, and I don't think that changes our motion in any fashion, because I still think we need to have one done and need one updated.
All right. I mean,
In relation to trial, Your Honor, obviously, we're going to need more time, but I do have permission from counsel in the guardianship, just to give you an update on that. Unfortunately, one of the attorneys is out of town this month for 2 weeks, so we haven't been able to conduct depositions. So we had tentatively discussed utilizing the first day of trial, which is October 16th, for the purposes of a mediation and trying to reach a resolution, which I think we're all optimistic about, which would automatically move that trial as well. So I only raised that because I know you were concerned about having this one before that one, but in light of those circumstances, I think we have a lot of more flexibility.
yeah, and I don't know. I'm not going to opine on which one is simpler or should be easier on the discovery or whatever. But I think, Mr. Standish, I think I have to give them an opportunity to do that at their expense and their.
I'd like to speak just because I was essentially representing myself, obviously, earlier before I retained Mr. Standish. Dr. Collins indicated she wasn't going to do a report in April or May. They've had all this time to request any discovery they wanted, but they wait until the eve of trial to request this motion simply because they like the current order of me not seeing the kids. They're not even following the current order, which says I get the kids Monday, 8 to 8. They've been neglecting that and not giving me my full time. So this is just clear. They knew they had to do this. They waited till the last minute, and I think it's completely improper to allow them to delay this case further. I mean, half the reason we're here is this case has gone on way too long. I deserve to have my trial and be able to get my kids back.
Your Honor, I'd like to respond to that because first of all, my motion to intervene wasn't even granted until the end of July. So my hands were in part tied. Setting that aside, we fully expected Dr. Collins' report to contain one, which is why we waited until after and filed the motion on an OST. And I disagree with Mr. Houston in regards to the time. As you know, the children started school. And there's an order that obviously says that they shall attend through kindergarten. And I realize there's an order that says Mr. Houston gets them from 8 to 8 today. On the first day of school, my clients informed him that they were taking him to kindergarten, or excuse me, the older one to kindergarten. And he was more than welcome to come to school to take first day of school pictures and everything. He objected to it because it was his custodial time. Well, it was something that the little girl was very excited about. And with on my direction, the clients took her to school, took her to his house immediately afterwards. And my understanding is they've given him the option. Do you want the children to go to school on Monday in light of the order, or do you want them at your house?
That's completely false. Completely false. They've never given me that option. I expressed my.
But it has to be in school. That's not an option. He's in
Well,
kindergarten.
I don't understand why they're making that same argument for because he's not in kindergarten. So
Right. I agree.
The main point is, Your Honor, we have filed a counter motion, so it's now before you, not necessarily today. I understand. I couldn't get it. I apologize to opposing counsel. And
I
especially
set
to
this
you,
on
Your
order
Honor.
shortening
It's
time, so
just-
not a big deal.
I don't know what I had over the weekend. I couldn't work, so it should have been done Friday night, but it got done just a couple of hours ago. But the point there is, all aside from the pages acting as the sole legal custodians over the children on the choice of school and many other issues, leaving that aside for the moment, when we're happy that they have the kids instead of Lexi because they have a better facility and house and everything. But leaving all that aside, our motion is basically on the theme, Your Honor, of it's way overdue for this temporary order to be modified. There's been nothing showing that Dylan is not competent and a good parent to have the children without supervision. And if you get a chance to read the counter motion, we set forth how the allegations from the other side, this whole case, long before Ms. Dwiggins was into the case, are just distorted and wrong about the testing and when he showed positive and all those things. We have audited the backtrack statements, and it's kind of shocking actually to know the real facts of this case on that level. And so we are asking the court, no matter what the trial date is, to please modify the order. And we mentioned, which we appreciate, that the pages several weeks ago, a month or so ago, said supervision was not necessary during his time, but they would not agree that he could drive the kids. And so Dylan is struggling with so little time with the kids and with not being able to drive them and so forth, so that he essentially needs his sister to supervise. That's the purpose of that motion. We would greatly appreciate if the court could hear that as soon as possible. Another date, obviously, opposing counsel needs a chance to respond, but we didn't have much time to respond to this motion, so I would hope
I understood.
they could.
And that I'm gonna.
We have been accommodating because, like, on Thursdays where his visitation is supposed to be from 2 to 6, we've changed it, I think, to 3:30 to 7:30. So he has that full time. The only time impacted right now is when the girl is in kindergarten.
So I think.
Your Honor, please, in this litigation, the only time his time was restricted was 2.5 years ago, when the first motion that was filed, he did test positive for cocaine once. And then 2 months later, he was clean and has been clean ever since. He was restricted to his time then, but the rest of the time, while the backtrack and everything else was going on, he had shared physical custody with Ashley. This is the first time in the last 2.5 years after that, that the court all of a sudden, because of this hysteria following the shooting, I understand how horrible it was for everybody and why the other side brought what they said. But honestly, the petition filed by Jones and Lobello is a disgrace. I mean, it said things they had no proof of. They accused him basically of planning the murder with his father. I mean, it was preposterous. It was outrageous. And now he has for 4.5 months barely 20% of the time with his kids. That's all we're asking the court to do, is to take a common sense look at the real evidence in this case. There's no danger to the children, and certainly his timeshare should be increased to at least 50%. That's what the purpose of that motion was.
And we'd obviously like a chance to respond to it in writing. We disagree with his assessment of the facts in this case, but the time restriction that occurred in April was not only because of the events, but there was a pending motion by Ashley for primary custody because of concerns that she had relative to the children's safety. Those concerns didn't change because of the events that occurred in April of this year. And again, we'd like the opportunity to respond. We disagree with a lot that they state in here and how many times he has failed the test. And as Your Honor is aware, missing a test is deemed a fail. And in that connection, he has failed several or missed several, even since the April order, which we will bring in front of Your Honor in opposition.
All right, I'm going to continue that counter motion till, I hope you guys are available, October 30th at 11. That way that gives a chance for me to, yeah, I'm sorry, not October, September.
Okay.
Sorry, September 30th. I'm sorry. If I could read, I'd be okay. Because October's right next to it. September 30th at 11 a.m. Hoping that you guys can all do that. And then that'll give.
I'm available, Your Honor.
I would like to have the reply by no later than the 26th. That means that it just got served, but I'm going to truncate your opposition time. Can you have your opposition done by the 20th of September?
Yes, Your Honor.
And then that way, Mr. Standish will have 6 days there to do a reply if there's anything else I need to, because frankly, I haven't gone back and read the only thing I've read is from the motion on April 8th forward. I haven't read the motion that was filed before the tragedy. So I have to I'm not familiar with all these things. I know like you did fail the cocaine test, but I didn't know how long ago that was.
Yes.
That's positive for cocaine. So, but from what is in here are the pages okay with him having unsupervised, just not the driving, as long as he continues to do the backtrack? I'm trying to figure out.
Yes, Your Honor. And one of the reasons why we agreed to unsupervised is there were a lot of incidences when my client was picking them up at Taylor's house, or the location was constantly being moved, and they were forced at one time to pick them up from Kelly's house, which, as you can imagine, was a little difficult for my clients. Became a complete game, and they noticed how should I say it? We felt the individuals that they were in the presence of might not have been best for the children, so and their best interests. So that was one of the reasons why we agreed to unsupervised, but we still have concerns regarding him drinking and driving, potentially using drugs. The fact that he has missed some of the backtracks. So, I mean, obviously we intend on putting that in writing in relation to the opposition, but
If I just wanted to get the stipulation on that, do you agree his time could be unsupervised that he currently has? So we got that stipulation on there. You don't agree the driving, but they're doing all the driving, right?
Correct.
And they're dropping off and picking up at your client's house now, Mr. Standish?
Well, no, the kids have other things going on and they need to be driven if you're their parent.
I get that.
And so
I'm going to determine that on
that part of
September
the order
30th.
Be still in place really doesn't relax the supervision that much, is all I'm saying.
I understand, and I understand you want more time. I'm going to deal with those on September 30th. I'm just trying to get on what we do agree, and they've agreed that can be with dad on Mondays and not go to preschool. Right. So we got some things that are better, and then the rest is going to have to wait till 3 weeks on the driving, on the more time. But he's agreeing to stay on the backtrack for now too, right?
Yes.
Okay. So if you want to do the 33, I'm not willing to continue this past the end of the year. So that means that you guys aren't going to like the trial dates. I can give you trial dates on December 23rd, 24th, and 26th, or December 30th, 31st, and 2nd. Those would be your 3 full days there. Which
I'm
would
sorry,
you
what were
prefer?
the other days, the 30th?
The 30th, the 31st, and January 2nd. The 2 Wednesdays. I can't. I would have trial, but I can't because there won't be anybody here at the courthouse.
Your Honor, I have a couple of comments as well.
Okay, just hold on. Just hold on. Look at the trial date, not settled down if that's what you want. If you guys don't want to do it, I can keep the trial dates where they are.
I'm not sure we could have the psych eval done. We have reached out to a couple individuals and tried to find out their schedules.
I would.
And
I
we're
could make
being
a
told it can't be
suggestion.
done this
I
month.
like letting council pick their own, so I'm not endorsing anybody, but in this case, it's too bad. Maybe a psychiatrist might be a better pick to do that, but they cannot, even if you got the raw data from Dr. Collins, a psychiatrist cannot interpret those psychometric testing. But they would be looking at different things, but you gotta get it done, because I can extend I can give you time, but I'm not gonna give you more than that. So you can pick the latest dates.
I'm sorry, Your Honor, the
The December fine,
December was 23.
23, 24, and 26.
Yeah, I absolutely cannot do that.
Well, she.
Well, yeah, you definitely don't have to be here for the custody trial.
Okay,
Let's-
they were consolidated, so are we going to hear guardianship and custody separately?
I'm gonna hear the guardian of the estate issue separately, yeah. I just don't think we have time, and the issues are so different in that case.
Okay,
I don't know if we need an evidentiary hearing on that right this minute anyway. But I would extend I need to extend the temporary again. When is the temporary on the guardianship of the estate expire?
I think it was October 9th. It was.
Right, the last day of trial rights.
Yeah.
So we would need to extend that. But I think that we just don't have to have anything on the guardianship of the estate. We'll just do the
Oh.
custody case. So would you be available on the week of the 30th, December 30th? Ms. Dalia-Hunt?
oh, yes, that's better.
It's better.
I rather.
Nobody- Right, but you guys are gonna have to,
I stay home on New Year's. Neither one of us will be hungover on the second.
I won't be, so.
I refuse to go out on New Year's.
Ms. Dwiggins and I are boring in that area.
Yeah, I think I'm in
So,
bed by
all right.
9 o'clock.
Let me see. I may need to move, I have a guardianship trial on the 30th. Why did I put that there? I'm gonna move that trial to a different time. Luckily, it's not your case, Ms. Dalia-Hunt. So we'll set it for the 30th, 31st, and 2nd, full days, 9 a.m. And so you've got to get the work done. That expert report, when do we want it due, Mr. Standish? Because that's going to affect whether you want to get a rebuttal expert.
Yes, but I'd like to clarify what that is that you're ordering, Your Honor. My understanding in the system is that a psych eval is a MD psychiatrist who, if there are any records, they will look at them. Otherwise, they do usually a 1-hour interview with the subject, and they write a report as to whether they have diagnosed any pathology from that. A psychological examination, I don't know what that is. I've never really heard of that before. I guess part of a child custody evaluation with a PhD psychologist means they can give the psychometric testing, they can do the standardized testing, and they can interpret those results. That would be different. That would be sort of like a very mini child custody that's only restricted to, they give Dylan the tests and then your PhD psychologist, I assume would have to be, interprets those tests. Those are two different worlds. I'm not sure which you're ordering, Your Honor. I think that we obviously oppose both of them. But I think it has to be one or the other. I would just like to know so that I can plan for if I need rebuttal, who I would line up to do that.
Ms. Dwiggins, were you planning on doing PhD or a psychiatrist or?
A psychiatrist, but we want a full psychometric testing where tests are actually done.
Psychiatrists can't give those. They don't give
And we're
them.
gonna have to find one.
Yeah, so you're gonna do both a PhD and a psychiatrist?
If we have to, yes.
But that means I have to hire two experts because those two worlds do not cross over in my understanding. Your Honor. It's one or the other. I mean, we're talking about a fitness to parents.
It's really, yeah,
a
that's the
child.
question,
So,
is the fitness
I
to
mean,
parent. So, but it could be both. It could be a medical or neurological issue could be involved in a case, or substance abuse. I don't know. And we're all hampered by that. We don't even have the raw data. I think we may need a specific order if you want me to get the raw data, because she did the test. We know she was almost done with the report. So we know she did psychometric testing on both parents. So there should be raw data available, and that should be available to both of you. What?
It should be.
Well, I'll give her a call. I know she has, what's the word? Contractual issues with the makers of the test, maybe on the MMPI 3. So a court order that she specifically released the raw data to all the counsel would be there, or to do it to the court and I can give it to you. I don't care. I just didn't want the big pile of paper that each party gave her. I didn't want to be responsible for that. But if you want me to order that, I will do that. So you have that information. I think if we're going to do this and get it done on the trial done on December 30th, we need to put some specific deadlines in place so everybody's on the same page of when the expert will be designated. And then I can definitely, and you're going to have to set, and once you designate, you're going to have to send me an order under NRCP 35 that orders him to appear at a specific date and time. So hopefully you'll coordinate that with Mr. Standish, and then.
Yeah, counsel, we haven't met to discuss dates. For example, I probably will try to engage some sort of backtrack expert because there's been so much controversy over that. And our audit of those, all those reports and data sounds like it's very different than the other sides, but so we're gonna need deadlines for probably more than one expert, right? End of October,
Yeah, I was thinking the end of October.
first week of November, or something that gives us 6 weeks or so to trial, yes. I mean,
But typically, I mean, some things in family court we do differently than they do in civil cases, in terms of you guys don't usually designate until they're done and they do the report, right? Except you got to designate if you need me to do an order under Rule 35 for him to appear in front of a designated expert. And
I'm fine designated before then, as long as we use like the
Okay.
end of October for completion.
yeah, because can you guys designate your expert by the 30th of this month? That's 3 weeks from today. Or you need more time than that? I like to have some
I
deadlines
think we can.
very specifically. So the interveners are going to designate by the 30th of September, just the name and CV of who you're doing. And then at that point in time, give Mr. Standish an order to review and sign with the Rule 35 order on the where and when. Has to be specific in there. And then the expert reports need to be due. Can you get that? You think you can get that done by October 31st or November 1st is a Friday?
That should be sufficient.
Because I think what are the rules only give you a very limited time, Mr. Standish, to do a rebuttal, right?
yes.
But you have
Usually
more
30
access to your
days.
client if you wanted to do. Up to you. So no, November 1st, then the intervener's expert report will be due. And then whatever, I don't remember, it's 15 days on a rebuttal report? It's very short.
Well, we both may need to flex those days, but we know the rule is it's a quick turnaround.
Right.
Maybe we could do November 29th, just because we have the intervening holidays.
November 29th for
Or
the rebuttal.
actually, sorry, the 20, that's Thanksgiving weekend.
Yeah, how
We
about
have
the
it by the
20?
27th.
Okay. That should be plenty of time to get a rebuttal report, because I'm gonna hold you to these deadlines. If you don't have it, it's not gonna be admissible. And the expert's not gonna testify, because we're not gonna allow anybody to do trial by ambush on expert witnesses especially. And I'm trying to balance the interest. Dad's right that he has the right to have this trial sooner rather than later, as soon as possible. But I also have to balance the intervener's right to put on the case. And that's why I picked the end of the year. I want to get this done. I'm also supposed to get these resolved in 6. I think that was already out the window when case got reassigned to me. And then the calendar call, we're going to move the calendar call from where it is in October to December. They get ready to take that December 19th the date, but you guys do 8:45 on Thursday, December 19th for the calendar call.
Yes, Your Honor.
That's
You
fine.
guys can definitely all be by video, so that for a calendar call, we just need to make sure nothing unexpected came up.
Right,
And
and-
ready for that trial. Yes,
Sorry, just to clarify, so initially this trial was supposed to involve
Include.
both the both the guardianship
Yes.
of the estate, as well as the custody issues.
yes.
Is that no longer anticipated? It's only going to relate to custody?
It's only going to be the
Okay.
custody case.
Okay.
The intervener's motion for or petition for custody and or visitation. So those are the things that are there. You're welcome to participate, but you don't have to because you have not made that choice. And my order on the guardianship's clear. So we will deal with the guardianship of the estate a different date. But on September 30th, Ms. Dwiggins, don't forget to remind me to do the extension on the temporary estate guardianship
Okay.
document for.
And then while we're here, Your Honor, just to give you an update on the legal guardianship. Guardianship of the estate.
Yes.
We have filed a petition to open a probate for Joe Houston, which is set to be heard on September 20th, which
Okay.
is next Friday. And once that's filed, then and someone's appointed, then wrongful death actions will be filed.
All right. And then Ms. Dwiggins, can you prepare the order from today?
Of course.
We'll issue you a new trial management order. So everybody has that on the same page, but put all of those deadlines we've all put in there.
Your Honor.
We have clarification, what's the court's ruling then on psychiatrist versus psychologist?
I really don't want to get involved in picking people's experts. It's a bad thing for the judge to get involved in doing that. So if they want both, I don't know that they need both. I don't know that there was anything, I don't know that he's had any hospitalizations or things like that. It's more on the substance abuse and for lack of a better word, the lack of self-control in terms of how he communicates with people. If those
Correct.
text messages are correct and emails are correct, that I don't know if there's an authenticity objection is what I mean. If those are accurate, then there definitely is inappropriate communication there that's completely unnecessary and not conducive to that. So I'm still hopeful you guys can settle this case, but I
No
don't know if
chance.
that's already been all fully explored. I always
I think
hope,
there's still some exploration.
yes.
Your Honor, I have a couple comments just because, like I said, I was.
Hold on. That is not a psychiatric issue, Your Honor. So I'm assuming they are going to be hiring a PhD. They can't have it every which way. I mean, should I be examining the pages and having them tested as well? I mean, I'm just saying, this litigation has been too broad, too long, with too many unfounded allegations already. And I just don't want to make it worse. I'm sorry. That's why I'm asking.
I agree with you, and much more expensive for a psychiatrist, but I don't know, and I don't know if you need it. I don't know that it's a medical issue as much as you need a PhD.
Could we see, Your Honor, because you mentioned of you reaching out, your chambers reaching out to Dr. Collins to see if there is the raw data from the other tests that we could potentially.
Yes, I agree with that.
Yes, no, give me an order.
Yeah.
There's raw data. Give me an order, Mr. Dwiggins, a separate order directed directly to her to release those. So that will alleviate her any contractual problems she has and why you didn't get them, and let's have it provided to the court so then we can make sure everybody gets it and submit that. It shouldn't be many pages on the raw data for each, and you can have it for both parents. I don't know that it matters on the other parent, but if you want it mostly because of this change in the case, and it is focused on dad's fitness, and then as well as the alternate relief of visitation. So I don't know if you need an expert, if you have some concerns, Mr. Standish, I'm happy to sign a Rule 35 order for you as well for any of the pages you think that there has to be. There is a reasonable basis for what they're asking for based upon the evidence so far. So I am granting an IME basically. So I think, are we gonna, Mr. Wiggins, do you have the ability to say today, yes, we're gonna do a PhD and not do a psychiatrist, or?
Not entirely. We have consulted with a couple people. And I think it in part depends now if there is raw data that.
Right, you'd
From-
still need a PhD to review and interpret the raw data, but that's at least what they tell me. I am not a psychologist for sure. So the designation has to be by the 30th. If there's an issue, we can talk about it on the 30th as well, because we're going to come back and talk about what the temporary custodial orders are going to be.
Yes, Your Honor.
All right. And Mr. Stanish, I don't have an understanding, and I get why there wouldn't be an updated financial disclosure form from your client on this. It would help me to know if he has a work schedule too. If he's back to work, and my understanding is he wasn't working.
No, he's been
But-
back to work for quite a while.
Okay, so he has a work
Working full
schedule
time.
as well to work around. Okay, that's, if you let me know what that exactly is, and we'll go from there, okay?
I'm sorry, his work schedule, you're saying?
Yes.
Yes.
and for the 30th, I need to know that for the 30th on what I'm gonna do with the temporary custodial schedule.
Yes, we'll supplement our motion.
Okay, I'll put it in the reply, that's fine. I just want to make sure I have that,
Thank you.
what his work schedule is. All right. So Mr. Wiggins going to prepare 2 orders, one for Dr. Collins, one for what granted today. And then you guys have your continued hearing on the custodial schedule. or
Your
the
Honor.
temporary Custodial
Your Honor.
schedule.
Can I make a comment?
Mr. Houston, you might want to talk with your client, your attorney, sorry.
Well,
first.
this happened during the point when I was representing myself. I presented, and based on what Miss Wiggins just represented, like there's still a drug issue. I presented for a drug test the day after the shooting voluntarily. I had those results sent to John Jones. He's withheld them from me and the court since then. Presumably, Mr. Wiggins has them as well, since she received her file from Mr. Jones. So I would like an order that they have to produce those results to us. And obviously, the
Was
fact,
that at ATI?
yes.
I'm not aware of it, but if they exist, I will obtain them.
All right, put that in the order that if Mr. Jones has them, that he'll share them with all the other council. That's fine. Anything else, Mr. Houston, that we need to deal with today?
No, I mean, there were some serious misrepresentations, but I think that's the most important one that can be easily dealt with.
Yeah, and we're gonna deal with that on the 30th. So I'm not making any ruling on your counter motion today. I did get their
Understood.
stipulation on what is stipulated so that we're all on the same page. You don't have to have supervised visits. You can have on Mondays, while it definitely has to go to school. All right, thank you all.
Thank you.